Hello, and welcome to this edition of NLS Now Live Update, Thursdays with NLS Now. Sorry, I feel like this is a radio program. Anyway, I am Ray Gertkin with Nevada Legal Services, and I'm joined by David Olshan. Hi, David.
Hello.
And today we're going to be talking about tenants' rights, specifically lease terminations and obligations. We're going to start talking about the lease obligations of landlords and tenants, and then talk briefly about how a tenant can terminate a lease. So with that said, we'll go ahead and get started. And then just first, as always, this information is for educational purposes only. We are not creating an attorney-client relationship with anyone. If you would like legal advice, please contact an attorney or call us to see if you qualify for assistance. And some of the information that we're going to discuss today, most of which will come from the Nevada Revised Statutes, Chapter 118A, which deals with essentially tenants' rights. You can also find more information on our website, which is www.nevadalegalservices.org. All right. So lease obligations, as I indicated in the beginning, both landlords and tenants have obligations under lease agreements and Nevada law, which is specifically in Chapter 118A. If you live in subsidized housing, we'll talk briefly about federal subsidies that can impact your landlord's lease requirements. Under federal law, there might be additional obligations and protections. So we'll touch on that briefly, but mostly we'll focus on Chapter 118A. In Chapter 118A, there are some basic obligations for tenants that includes complying with the lease agreement. I guess the first thing I will say is, for the most part, the lease agreement controls. There are, other items prohibiting certain lease provisions, requiring certain lease provisions. We'll get into that in a second. But I do want to make clear that the lease agreement is a binding contract and pretty much is the governing document to most tenancies. Judges will almost always defer to the lease agreement. So just keep that in mind. But basic obligations are to keep the unit clean, don't damage it, don't destroy it, don't deface it, don't disturb your neighbors. And that includes your guests. Your guests, you are responsible for the actions of your guests on the property. So, it's really to keep the unit clean, safe, and not destroy anything. Yes, David.
No, I just saw embedded fonts, and it's like, what's going on?
I have no idea.
I can say that leases are a joke, that a landlord will put in hundreds of obligations and rules, and most of them, for the majority of the people, are not enforced. And so you can look at this and say, do I have to do this or that? And it really is a trick that landlords use. And if they don't like you and you happen to be of a particular race or ethnicity, they may enforce them. They may enforce them to the letter of the lease. And for other people, for white people, for instance, they may not. That's how systemic racism factors into a lot of these situations. So a lot of it is at the discretion of the on-site manager. And that's the key here, is that for a lot of these issues, they won't be issues if you have a reasonable, objective on-site manager. It's sometimes hard to figure out, but if you're thinking about moving or moving in, you may want to talk to people who live there and see what the manager is like, because reasonableness and fairness go a long way in these situations.
And also, it's also a fiction that the lease agreement is a negotiable contract. In most cases, right, you have very little power to negotiate any changes with your landlord. Again, as David said, maybe if you're white, if you're educated, if you have a certain background, maybe, your landlord is willing to change certain items in the lease agreement to have you as a tenant, whereas other people will not have that. And I will say, it's not something that, even lawyers would necessarily be able to negotiate a lease agreement, as a tenant. I'm not saying, obviously in their jobs, but if you're a tenant and a lawyer, again, these are really one-way contracts. There's not much negotiating being done. As I mentioned, though, Nevada law does mandate and restrict what can be in a lease agreement to a certain extent. So that's in Chapter 118A, 200 to 230. And, some of the provisions that are in lease agreements are required by the statute if they're in writing. So if a lease agreement is in writing, 118A, 200 will require certain information to be there. But leases don't have to be in writing. So if you have an oral contract with a landlord, none of that applies. It does prohibit certain provisions in the lease, and we'll get to that in a second. There are restrictions to late fees. So late fees can only be 5% of your rent. And then there is a provision that allows if any provision in the lease agreement is considered unconscionable, which David, if you want to go through what that means, you can. There are ways to potentially challenge leases, but again, as I indicated, they're binding contracts. Unfortunately, a lot of courts will look at that and say, well, you agreed to it. It just depends really on the judge and what the provision is and whether it can be considered unconscionable.
Unconscionable, something that shocks the conscience. Late fees, late fees have a statutory cap. Rent increase, no, not a rent increase. Maybe rent increases from $100 to $1 million or $100,000. Maybe that's unconscionable, but there is a lot of discretion before something becomes unconscionable. So if it burdens you and it creates stress, it doesn't necessarily mean it's unconscionable. So that's a lot of, this is an objective standard. It's not a subjective standard. If you're relying on unconscionability, you don't necessarily have a good case. And the other thing I wanted to say, and sorry, I'm interrupting potentially, but a lease longer than a year has to be in writing, or it should be in writing. And I think, we talked about the multitude of terms that are in a lease. Oftentimes, you're much better off with a lease than without a lease. A lot of promises are made, and if you can't prove them, if you can't establish them, you're going to lose. And I think a lot of shoddy landlords I trust you, so I'm going to let you in and hit the bricks. I promised you 6 months, but sorry, you got to leave today. So you're probably better off with a 12 to 15 page lease than with nothing.
Right. And, we see a lot of oral agreements, the whole "my word is my bond" thing, right, where the landlord says, yeah, I'll give you a discount on the rent if you do repairs or something like that. None of that is in writing. Believe me, you basically just agreed to do the repairs and to pay the rent. So keep in mind that if there is anything that you're agreeing with your landlord about and it's not in writing, you're going to have a very hard time proving that in court. All right. And then just, to piggyback off of one other thing David said, there is now a cap on late fees. It is 5% of the periodic rent. There is no cap on rent. There's no rent control. There's no, like David said, maybe from 100 to 1 million, that would be considered unconscionable, but in no other way is there any restriction on rent increases right now. So please also keep that in mind.
There is 60 days notice if you're not on a lease. If you're on a lease, the landlord can't increase the rent
until the lease is expired. All right, so there are, as I said, some prohibited lease provisions. Just to make sure that everyone is aware of them, we'll go through those briefly. But it's really about protecting the tenant from waiving any statutory rights that they might have, or in some ways limiting the landlord's liability for future bad acts. So the tenant, through the lease cannot waive or forgo rights or remedies that are provided by law. So if a statute says something, the contract cannot abridge that. I feel like there's still some judges that don't agree with that, but for whatever reason, again, contracts are held to a little bit higher standard, but your lease agreement, if it has a provision that directly violates a provision of 118A, it is not going to be enforceable. A landlord cannot require a tenant to confess judgment. And what that means is, yes, I will pay you if there's any claims that you have against me. So,
the force of law, with the force of law.
Right.
So you basically
that they can't force you to, they can't force you to pay any money without getting a court order that they can then enforce. So they can't require a tenant to agree to it beforehand. The tenant can't agree to pay attorney's fees, although please be aware, if your landlord prevails in any court action, it is possible that you would be required to pay attorney's fees. So that's kind of a limited thing, but it is only required when there's court action involved. So, you know, that is in the statute. The landlord also cannot limit their own liability for their future bad acts. So they can't say in the lease agreement, you know, I'm not going to take responsibility for anything that happens in the future. Obviously, you know, there's a lot of things that landlords can do that either violate the lease or they have to make repairs for habitability reasons. They can't say that it's, you know, I am not responsible for any of that. They have to comply with Chapter 40's notice provisions for eviction. They can't mandate in the lease agreement any different notices. Those are all required by law. And then finally, there are some other provisions. As I said, subsidized housing does have a little bit higher standards for lease agreements. And so for things like Section 8 tenants, public housing, you know, public housing actually is 100% like a federal lease, although they can evict people through the state eviction process. For Section 8 voucher holders, there are other restrictions like the amount of rent a tenant pays is set by the housing authority, and the landlord cannot require the tenant to pay any additional rent than what's required by the lease or the housing authority's payment agreement. So just keep in mind, if you're in subsidized housing, some of these things will be also heightened.
One of the things that, you know, we should mention too is landlords requiring you to get renter's insurance, and doesn't that limit the landlord's liability and possibly violate Chapter 118A? And renter's insurance really became popular, I guess, about 20 years ago, and it's probably in a lot of these higher end apartments and apartment homes and townhouses. And they basically require you to get insurance and name the landlord as the beneficiary. So I think in those situations, it possibly does violate NRS Chapter 118A because you're limiting the landlord's liability.
Interesting. I had not run across that, but that is interesting.
No, that it's I don't even know why insurance companies write it, but if they make money, then I guess they're going to write it.
Yeah.
The policy.
All right. So we've talked a lot about the tenant's obligations and what can be in lease agreements. There are additional obligations of landlords. The most basic one is that the landlord has to deliver possession of the dwelling to the tenant. Tenants do enjoy exclusive occupancy to their dwelling units. You know, we're going to talk later about the landlord's ability to access the unit. But, you know, the landlord has to deliver exclusive possession of the dwelling to the tenant. Some tenants, you know, they might not get the keys on the day the lease starts. Like, that is a violation of the law. Additionally, there are requirements that landlords return security deposits within 30 days. And if they sell the property, they either have to return the security deposit to the tenant at that time or transfer it to the new owner. They have to disclose the name and address of managers and owners. So if there's somebody who's managing the business, the premises, sorry, they have to identify the name and address of that person. They have to identify a person who can receive service of process notices and demands. So in the lease agreement, they have to provide, like, if you have a notice, if you have a demand, you send it this way. Identify the principal or corporate owner of the property and provide a phone number for a responsible person to call for emergencies. I do see a lot of lease agreements that do not contain this information. So it is something that the landlord is obligated to provide the tenant. I believe that sometimes this doesn't happen. And I will say a lot of times for out-of-state landlords.
Well,
There are some other obligations. Sorry, David, go ahead.
no, I mean, just it's a landlord's market. I mean, with housing and rental units so expensive and so much in demand, the landlord can dictate a lot of these provisions and violate the law in the process because people are willing to basically pay anything to get into a nice apartment.
And there are some other obligations that landlords have. That's providing receipts for rent and security deposit, disclosing any foreclosure proceedings that came in the 2009-2010 foreclosure crisis. They do have to maintain a habitable dwelling, and that is a whole other set of obligations we're actually not going to go into today. We do have a habitability video on our YouTube channel that you can look at after this if you are interested in more dealing with habitability issues. And then, as David mentioned earlier, there is an obligation to provide 60 days notice of any increase in rent. That's, of course, if the lease agreement is month to month or so after it's expired, so not within a written term lease agreement.
And one thing I want to mention is there's no as-is rentals in Nevada. The landlord has to supply, deliver possession at the start of the lease term in a habitable condition.
Correct.
So you can't have as-is, oh, it's a fixer-upper, I'll take $100 off the rent. That's illegal. The landlord has to rent to you a habitable dwelling. And if it's not habitable, it's against the law. And again, if it's a landlords who are in control and there's a scarcity of affordable housing, perhaps you will be taken advantage of, and a landlord can violate this law. And if you agree to it, no one's the wiser. But just realize, no, legally a landlord can't rent an apartment as is.
And there are specific requirements for what makes a unit habitable, and that is in 118A. Again, like I said, we do have habitability videos that go through that, but they are in 118A.
Well, right, but I mean, right, this goes, I mean, it's a collapsed roof or something.
Yeah,
no running
it's not
water.
like, the flooring is kind of messed up and things like that.
Right. You don't need to be a lawyer. Anyway.
Yeah. As I've mentioned before, if you are in subsidized housing, and some examples are Section 8 tenant-based vouchers, low-income housing tax credit properties, project-based Section 8 if HUD is involved, or if it's the public housing and the housing authority is involved, you do have more protection than just Nevada law. And that is on a scale of less protection for, say, Section 8 tenant-based voucher holders to the greatest protection in public housing. So if you are in subsidized housing, there might be additional protections. Your lease will often reference a subsidy if there is one. For example, low-income housing tax credit properties will reference something called Section 42, and that's Section 42 of the IRS code. And those lease agreements are automatically renewed. So the landlord always has to have cause to evict somebody from a tax credit property. That's basically the only protection. But it is significant. Section 8 tenant-based voucher holders, of course, after the first year of their lease, may get a notice that they have to move. For all of these other subsidized housing providers, that's not the case. So it does restrict when leases can be terminated, except, like I said, in the Section 8 tenant-based voucher context. After the first year of the lease, the landlord can issue a tenant a 30-day notice without cause. That is not true for any of the other housing types I've listed here.
It's like interesting. Housing quality standards will have meticulous details regarding lead paint and what constitutes lead-based paint. And do you ever see lead-based paint anymore? I don't think so. I don't think it's even sold in the United States, but that regulation is still there.
Yes, the housing authorities do. I mean, they're very complicated potential housing situations, but public housing is like your lease could be 20, 30 pages long. All right, so we've talked a lot about the lease agreements, what can be in them, what can't be in them. One of the things I want to make clear is that written lease agreements can only be modified in writing with the consent of both the landlord and the tenant. So when we're talking about rules and regulations, we are not talking about things that would modify the terms of a lease agreement. We're talking about additional rules and regulations that benefit the community itself. They have to be, sort of for the benefit of the common areas, for the landlord and the tenant, and have to apply to everyone in a fair manner. It cannot individually affect your lease agreement. So we're not talking about, landlords cannot use this to kind of get around lease agreements, is what I'll say. If there's a modification to your written lease agreement, again, we're talking about written lease agreements, not oral agreements. but written lease agreements can only be modified in writing if the landlord and tenant both consent.
And, you could see, oh, I have supply chain issues or inflation. I'm going to start charging you $20 a month for heat surcharge or air conditioning surcharge. The landlord can't do that. If there's going to be any change, it can't be, we're going to charge you more money, because that's locked in by the lease. And that's, I think, an important area. A landlord will point to this rule and say, oh, I can change this anytime because it says right here I can change. No. This is house rules that pretty much apply to everyone. And you could say, yeah, we're going to have a $20 surcharge, but these rules can't benefit the landlord financially. There can't be increased charges. And that's one of the things you can't change, is anything that affects the payments of the landlord.
Right. The amount that the tenant pays cannot be affected by a rule or regulation. That would have to be a lease modification. But, anything that has to do with the pool or any facilities, common areas, things like that can be done by rule or regulation and can be enforced after 30 days written notice. I don't know if anybody's challenged it in terms of they have to be clear so the tenant can easily comply. They have to be done in good faith and not to avoid other obligations. I know landlords try to use rules and regulations to get around this. So I don't know, David, if you've had much experience challenging these rules and regulations, but it is potentially possible to do.
Nothing comes to mind, but I do see a lot of times landlords want to tack on charges, and it's simply not allowed under this provision.
As I mentioned earlier, the fundamental duty of a landlord is to deliver exclusive possession of the rental premises to the tenant. There is a provision in Chapter 118A that deals with when a landlord can access the unit. Generally, because the unit is the exclusive possession of the tenant during the lease term, the landlord can only access the unit with the tenant's consent. Unless it's an emergency, and the landlord can access the unit without consent. This provision, though, basically says that the tenant cannot unreasonably withhold consent to do certain things in the unit, and that's inspect the premises, make necessary agreed upon repairs or improvements, supply necessary agreed services, like if there's a hookup for AC or heat or something, the landlord needs to get in there to make sure that that operates correctly, and to show the unit to prospective purchasers or tenants. The landlord has to provide 24 hours notice of their intent to enter and may only enter at reasonable times. And they can't abuse the right of access or use it to harass the tenant. Again, this is one of those where, yes, it says this in the law. I don't know if it's obviously not followed, most of the time. But I also am not aware of any successful challenges to this abusing the right of access or using it to harass the tenant. We do a lot of times demand landlords stop accessing the unit and allege this, but as far as getting this in front of a judge, I'm not sure about the success rate. But generally speaking, these are the reasons that a tenant or a landlord should only be able to access the unit, and only if the tenant is unreasonably holding consent, would the landlord be able to do it without the tenant's consent. So just laying that out there.
I believe there's a remedy in the statute, and that is to get a restraining order to stop the landlord, and for $25 in penalties, something like that. It's really minimal. And I can tell you that this is a point of contention. I believe that when you're renting, you do believe it's your home and that no one should enter. It's your castle, whatever. But I also think landlords say that's my home because I have title to it. So there's this conflict where a landlord will want to enter without notice, and the tenant will say, "Go F yourself." It does provide a lot of problems, especially if the house is up for sale or the dwelling is up for sale, because then you'll get real estate agents who aren't even the landlord coming in, and we know what real estate agents can be like. So a lockbox, for instance, that's not legal under Nevada law. You don't get 24 hours notice with a lockbox. So if there is a lockbox, you probably should get another lock for your door, because no one should enter when you're in the shower or doing something, doing a TikTok dance video or whatever. It's you're entitled to privacy, but just realize the landlord's going to think this is my home, so I can do whatever I want. And of course, you want your home to be a castle and don't want you want your privacy to be respected.
All right.
No, it does create a lot of conflict.
I know this is probably the most contentious area that we deal with, just in terms of day-to-day activities between landlords and tenants. All right, so we will end this presentation now. We've talked a lot about obligations and duties, but we'll talk about now, how can a tenant terminate a lease agreement? So again, as we said, if you have a written lease agreement that's for a term, say for a year, generally speaking, you cannot just turn in your keys and move out. Lease agreements, like we've said, are binding contracts. A lot of written lease agreements will have provisions that allow for early termination of the lease. This will often include a fee. Other leases might allow termination without penalty. Say, for example, you can have a written month-to-month agreement where the landlord and the tenant can terminate without cause, every month. That's entirely possible. But if you have a term lease, until that term ends, you are as bound by the lease agreement, obviously, as the landlord. There may be reasons why a tenant can terminate a lease early without penalty, because that's really what we're talking about, terminating a lease without penalty. And that's if the tenant has a physical or mental disability and needs to move in order to access care for that disability. Domestic violence survivors may also terminate leases to, get to safety, essentially, if the abuser has found out where they live or lived with them, essentially. Obviously, we've talked about potentially terminating the lease if there's habitability or essential services violations. Often that's a potential remedy if the tenant just wants to get out of the lease, if the landlord will not fix a habitability problem. There may be an option to terminate a lease on 7 days notice if the landlord is failing to comply with the lease. Sorry, not 7 days, 14 days notice. I believe it follows a similar process as the habitability terminations. And then finally, if the landlord fails to deliver the unit, or there's a fire or some other act of God that destroys the unit, then the tenant can get out of the unit also without penalty. Generally, these require notice to the landlord. For casualty, it's 7 days. As I said, for habitability, it's 14 days, essential services, 48 hours. The landlord's failure to comply with the lease, I believe, is also 14 days. Domestic violence, and I believe, is one where it can be retroactive, essentially. If the survivor has to leave because of the violence, they can terminate, basically say move out and then terminate. But there's a lot of requirements that go into what domestic violence survivor has to provide to the landlord. And that's essentially some verification of the abuse. But as soon as that happens, the domestic violence survivor is relieved of liability for the condition of that unit.
Let me just say, like physical or mental disability, it's probably one of the most poorly drafted statutes that we have in Nevada Revised Statute, NRS. Basically, first of all, under the statute, you need a doctor to recommend that you need medical care that isn't available where you're living. So that's a pretty high bar. Now, this is the statute. I think under the Fair Housing Act and accommodations, you can possibly get around that by simply not being able to take care of yourself and need to go into a nursing home or need to live with relatives or at-home care, something like that. That could be a legal reason to break a lease as an accommodation to allow you to stay housed, but stay independent, but not at the current place you're living at. And, a lot of people will say, my doctor's saying I need to go back and live with my relatives. That's really not a reason under the statute to break your lease. So if you do have this situation, be advised that, your doctor can say, yes, you can leave. Here's a doctor's note. That's probably not going to be sufficient. So you should consult with the law and follow the law, because if you're going to use it, you have to follow it.
All right, as I said, we're nearing the end of the presentation. If you guys do have any questions, please feel free to post that in the chat, and we'll stay on for a couple more minutes as we let people filter in any questions. But when we're talking about a landlord terminating a lease, because obviously we just talked about how a tenant can terminate a lease. Obviously, when we're talking about a landlord terminating a lease, we're talking about eviction. And the eviction process is in Chapter 40. Obviously 118A and 40 are read together in a lot of contexts when it comes to terminating a lease. But when we're talking about a landlord terminating a lease, we're talking about the eviction process. We have also videos on YouTube that go through the summary eviction process in Nevada, and you can watch those for more information about how a landlord terminates a tenant's lease agreement or a tenancy, whether there's a lease agreement or not, essentially. But that, as I said, will do it for today. Please feel free, as I said, if you have any questions or want to see if we can be of help, to contact us. We have online intake through our website, nevadalegalservices.org, or you can call any one of our local offices. Any final thoughts, David?
Yes, when you have an eviction on your record, so to speak, it does impair your ability to rent. So if you can talk to your landlord about not reporting it to a credit reporting agency, not filing for eviction, which is something you do here in Nevada, you get the notice. If you don't contest it, the landlord can still go in and get an eviction, and it's on your record. So tenants should be aware of that, with this tight housing market, having an eviction on your record could be the difference between renting and not renting in the future.
And we do have videos on eviction sealing. If you do have an eviction on your record, Nevada does allow you to seal that eviction. It is up to broad judicial discretion, so the judge gets to decide. Some judges will do it fairly easily, others won't do it at all. So as David said, it's always better to try to work things out with your landlord before there's an issue instead of after. And then we also have a video on getting your security deposit back, so keep that in mind. If you do have a security deposit issue, I know we talked about lease agreements and receipts for security deposits, and the landlord is obligated to return your security deposit within 30 days. We do have a video on how to get your security deposit back as well. But again, feel free to visit our website or call us if you would like further information. Again, we'll stay on for just another minute if there are any questions, and it is our pleasure to provide this information to you. So we appreciate any suggestions always for topics for future presentations, but thank you all for joining us today. Thank you, David.
Thank you, Ray.
And we'll go ahead and call it a day for today, and join us for our next Thursday live, which I'm blanking on the date, but it'll be the second Thursday in April. Maybe the 15th? No, I don't have my calendar up.
Yeah.
April 15th. Tax day.
Oh, no, it's not tax day. It's Good Friday.
Good Friday. Well, anyway, second Thursday in April.
Oh, shoot. Thursday. Yeah, it's the 14th.
The 14th. All right. April 14th.
Friday, yeah.
Somebody will be here. Anyway, thank you all.